Judges, would you like us all to introduce ourselves before we begin? Great. I'll just go ahead and go first then. I'm Cosette Calderon. I'm going to be the first affirmation or government speaker from Benicia.
My name is Dan Delgado. I'll be the second affirmation speaker from Benicia.
And hi, everyone. My name's Teddy Sipkins. I'll be the first and third speaker from Windward School on the opposition.
And I'm Carter, and I'll be the second speaker on the opposition.
Okay. Is everybody okay with off-time roadmaps, or would anybody prefer I just go into it? I'm not seeing any no's, so I'm going to go ahead and give one, if that's okay. Okay. So hello, my name is Cosette Calderon. Just a brief overview of what I'm going to be doing. I'm going to start with the top of case. We're going to provide the weighing mechanism for this round. We'll also provide some definitions, and then we will go on to our 3 contentions. I have 7 minutes on my clock. Verbal POIs are okay. I'll try to get to them if I have time. Okay, is everybody ready? Great. My 7-minute timer will begin in 3, 2, 1. Hello, judges. We strongly affirm the resolution that justice requires that criminal defendants have a right to refuse to testify. Let's first start with the top of case. We're going to start with some definitions. We define justice as giving somebody their just due. We define criminal defendants as a defendant in a criminal case who is accused of a crime. And then we define refuse to testify as to not speak on trial. We're going to define this as a value round. We're going to give the value of upholding justice, and we're going to say that the weighing mechanism is false or unfair convictions. Going on to our first contention, bodily autonomy. Our claim is that the right to one own's body should be considered first because this is the most important and immediate impact to oneself. Forcing somebody to testify goes against bodily autonomy. Warrant 1 to this, danger. Subpoint A, to force a criminal defendant to testify puts them at a potential risk of putting themselves in danger. Subpoint B, how does this exactly happen? Well, peoples may worsen their attacks on criminal defendants if they dislike the testimony given. It gives more motive to people to hurt them. Our second warrant to our first contention, the right to say no. Subpoint A, even criminals have certain rights. For example, bills of attainder and right of habeas corpus. This means that criminals can't be tried for something they did when it was once legal, and they must be given the evidence and charge against them. I to this, one of these rights is to the Fifth Amendment, which says one doesn't have to speak in trial if one doesn't wish to. Subpoint B. I'm sorry, I don't have time. I'll answer that at the end if I do. To say that criminal defendants don't have this constitutional right is taking away a constitutional right, which was made with keeping justice in mind. Subpoint C, justice. To give somewhere their just due is to follow actions that have a result of fairness. Subpoint D, criminal defendants that have not testified have still gotten convicted or released based on evidence, giving them whatever their due was. We're not preventing criminals from being convicted. Impacts. 1, to force people to testify takes away bodily autonomy, which is the degradation of humanity. It's dehumanizing, and this is the most important impact because once we dehumanize one another, it becomes easier to become more polarized, which leads to less justice actually being carried out fairly. Our second contention is coercion. By allowing the courts to force testimony, the courts gain leverage over the defendant, placing them in a position of coercion. Our first warrant to this, power imbalances in the court system. Subpoint A, defendants are placed in a difficult situation when testifying. They cannot lie or falsify without repercussion of perjury or obstruction of justice, and they are not allowed to remain silent under Naig's advocacy. Subpoint B, this gives the federal court direct leverage over them. Subpoint I, in the status quo, individuals can give up information or witness protection or plea deals. Subpoint C, by removing this leverage, the power balance goes significantly in favor to the courts, and this has several negative effects. 1, individuals placed in a situation where their own choice to self-incriminate or lie or incriminate innocent people to try to protect themselves. This basically means that people are going to self-incriminate because they either can't lie, or 2, they're going to lie because they have more motive to.
They lie out of desperation.
Because they lie out of desperation. There's no longer the incentive to tell the truth now that their only option is to speak. Their only option for self-preservation is to lie or falsely incriminate themselves. Our second warrant is power of the jury. Subpoint A, by forcing an individual to give testimony, it allows for more jury influence or abuse. Subpoint B, a testimony could be used not for the direct crime, but for the backgrounds or motivations of the defendant. Subpoint C, by forcing the defendant to reveal parts of their lives, juries have far more bias in their decision. Subpoint D, this actively reduces is reductionist in the trial. If a defendant is forced to reveal previous drug use or other bad practices, the jury is far more likely to be biased against them, even if what they did has nothing to do with the crime. Double I. If a reductionist, it is reductionist as it brings in more background information than is relevant, reducing the defendant to a bias. Subpoint E. This is a unique problem with the negation's advocacy. In the status quo, what is revealed by the defendant is limited to what is directly relevant to the trial, because that is what the defendant would want to reveal. Double I, by allowing forced testimony, trials can abuse people's past to use bias. What are the implications of this? Well, one, it's an unfair and biased legal system. By allowing greater circumstantial and background information in a trial, bias is greater in a case. And B, this directly undermines principle of a fair trial and justice. And two, we see more false convictions and incrimination. This ties directly back into the value criterion of seeing people get their justice due, upholding the legal system. Our third contention is unfairness. Our claim is, by forcing people to testify who are undergoing mental health issues or bad public speaking issues, there's an increased chance of false incrimination. Our first warrant, self-incrimination. Subpoint A, this happens when somebody confesses or provides evidence that incriminates themselves. Subpoint B, this can happen under pressure, coercion, or confusion. Our second warrant is that testifying can be unfair. Subpoint A, here's an example. People with a stutter look guilty because they look nervous, but they could just have a stutter. They could just have a stammer. Subpoint B, people who have depression, anxiety, or bipolar disorder or any other mental health issues can maybe have mental breakdowns due to pressure on the stands, which makes them look more guilty, even if they're innocent. Subpoint C, people who have mental health issues that may make them confused or etc. have an increased likelihood that they may misspeak and they may self-incriminate themselves based off of confusion. So what are the implications of this? Well, one, we see more false convictions go up. And two, we see a direct increase of suffering because of false guiltiness, imprisonment, etc. We're seeing direct suffering because of the negation's advocacy. So quick review. We believe that the most important impact in this round is to one's own self because it's the most immediate impact that you can focus on. That means that when we're considering who wins this round, it's whoever can uphold the justice system, meaning how do you weigh that? False or unfair convictions? Do they go up and or do they go down? We argue that in the affirmations world, they significantly decrease or they stay the same, which is better than the negations world where they're going to go up because of the three contentions that we gave you: bodily autonomy, coercion, and unfairness in the justice system. I strongly encourage an affirmation vote. Thank you.
Cool. Hi, everyone. Just as a reminder, my name is Teddy Sipkins. I'll be your first and third speaker today. If everyone's ready, I'll give a quick off-time roadmap. Cool. I'm going to go over some framework for this debate, make a few clarifications, then I'll go over my team's case, and then I'll do a line by line of my opponent's case. Okay, my 8 minutes will start in 3, 2, 1. All right. Hello, everyone. My partner and I strongly negate the resolution that justice requires that criminal defendants have a right to refuse to testify. So first, let's go over some framework stuff. So they define justice as like someone having their just due. We think this is a little vague, but we mainly agree with the concept. Like justice is the ethical, philosophical idea that people are to be treated impartially and fairly and reasonably by the law. We probably agree on this, but the most important definition in this round is one that they didn't actually provide. So don't let them come up here and then redefine it in their second speech. The most important definition in this round is the word requires, because the word requires means that we are not just saying that it is inherently necessary to have justice. We are saying that even if it helps justice along, it doesn't mean it's required here, right? The burden of the negation here is just to prove that in a single scenario in which justice is carried out, the right not to testify does not matter. Because if that right does not matter in just a single scenario in which justice was carried out, it proves that justice is able to happen without this right, and that therefore it is not required this right is not required in order for justice to happen. So just that, like, getting that out of the way, that is going to be the crux of this debate, what requires means. But also for the definition of right, we just like to say that like it's someone's inherent status as a person. For not the US, and also just for defining like the scope of this debate, our opponents really engage with a lot of like US centric arguments. We're going to say that this debate isn't about the US, and also they define it as a value round. We're going to say that it's not a value round. This doesn't really matter here, but because this doesn't matter in the long run, but because the topic is just a statement, it's a statement implying like true, a statement like whether, and we're supposed to debate whether or not it's true or not. The standard for this round should be truth. There's nothing implying like a sort of action should be taking, like a shift in a change of mind, state of mind, which is what a value round would be. And so what we're debating today is truth. That should be how you're weighing this round, which side is more true. Let's go over the case. Let's start with our case. So our first contention is going to be that testifying accelerates justice. So we tell you that the defendant is the best possible witness to accelerate justice, because no matter what, the true story comes from them. And we tell you that it allows for all perspectives in the court case and gives the defendant the opportunity to share their story, allowing justice to be served. And we tell you that they get up here and tell you like a lot of arguments about how like justice goes down and how like false convictions go up. But we tell you that acquittal rates go up when the defendant testifies because the jury is able to hear the full story. We tell you that because people don't actually, because the full story is told, because the witness, the criminal defendant is the one who can best tell the story, they are the ones that can actually make sure justice is served by telling the story. Like we say that defendants who testified had better sentencing outcomes compared to those that didn't, and were more likely to be acquitted of their serious offense and less likely to be sentenced to incarceration. And we tell you that this is because they give their alibis. They are able to let it come from their mouth, and they are the most convincing ones. The impact of this is like the impact of this is one, faster justice, which means more justice because justice is able to be processed faster. And we tell you that like wins this debate right there. But we also tell you that two, the impact of this is like more like acquittals, which means that more people are like getting fairly treated by the justice system. The second contention is this, and this is going to be the most important contention in this debate, is precedent. So we tell you that multiple countries have justice systems in which the defendant doesn't have the right to testify. And what happens there is actually more justice. Like there's much more justice because there's a lot less appeals, which means that more people are satisfied with the system. We tell you that Australia has mandatory testifying for the defendant, and their appeal rate is among the lowest in the world. We tell you that over 500,000 defendants had criminal cases in 2022 and 2023, but the number of these appeals were 522. This is a 0.1% of appeal rate. And what we tell you here is that this means that the, like either defendants or the prosecutors didn't feel like justice was misserved. They didn't feel like this, that we tell you that the people involved in the case felt that justice was served. And because of that, we tell you that despite the witness being forced to testify, despite the witness not having like the right not to testify, justice was still served. And we tell you only in 0.1% of cases did people think justice was not served. And so much like we tell you that because like 500,000 cases said that like justice was served, we win off of just one of those. But we also tell you that because like 500,000, like the vast majority of the time this happens and justice is actually served, that we're winning here just like on a numbers game. But our third contention is going to be that the right to not incriminate yourself is different than the right not to testify. Also, sorry if there's background noise.
Yes.
So this contention basically relies on the fact that the right not to incriminate yourself solves for any impacts that not having the right to be forced to testify has. We say that even if they come up here and say that the right to not incriminate yourself exists, we say that having to testify doesn't interfere with that because you can still avoid self-incrimination. Look to like the idea of pleading the fifth. Look to the idea of not having to incriminate yourself even if you're testifying. We tell you that defendants plead the fifth all the time, even if they're testifying. And because of that, justice is still served even if they are forced to testify. So the impact of this is that all of their impacts are solved by the, like having the right not to testify. But they said a lot, and so if there aren't any POCs or POIs, I'll get onto their case. Cool. Okay, starting off with their first contention of bodily autonomy. So we say, one, this doesn't even link out to their weighing mechanism of false or unfair convictions, because we tell you that violating bodily autonomy doesn't lead to unfair or false convictions. That's not really related to their impact. But two, we tell you that this impact, like again, gets completely like struck off the flow once we realize that acquittal rates go up when the defendant testifies. We say that this is actually the best way to protect their bodily autonomy because it's telling their full story. And it's putting themselves in the best position to be heard by a jury of their peers, right? We tell you that like their first warrant of danger, that like it puts themselves in danger. We say, no, it doesn't. It actually puts themselves in a better position. They say that they have the right to say no, and they have the right to say no. And then they also kind of say here that like they're not allowed to remain silent. We say that even if they're testifying, they're still allowed to remain silent. Also, they say that like defendants have certain rights. We say that yes, this is true, but it differs based on the country. We say that justice is able to be served just as well in like the UK than it is in the US, and that like overall we're not having like and overall, like different rights exist in both places. So like the Fifth Amendment and habeas corpus here, like don't necessarily apply. And like the constitutional rights thing doesn't apply because it's not just about the US. They say like criminals have been released, like, but by not having to testify. But again, we tell you that like acquittals get the full story out. And also that in most cases, justice is able to be served whether or not they have this right. On their impacts, they say it takes away bodily autonomy. Again, we're going to say that this doesn't link out, but also they say that there's less justice because of polarization. We say that we don't really understand this point because again, acquittals are able to like moderate the jury more. They're able to humanize the defendant to the jury. On coercion, which is their second contention, they say that there's power imbalances in the court system. We say that this is where the are not allowed to remain silent thing comes in. We say, again, that's just not true. Like even in Australia, when they have to testify, they're allowed to remain silent if they choose to. On defendants, like they say defendants are put in a bad place, but again, we tell them that acquittals are the best, but like testifying for yourself is the best possible way to get an acquittal. They say it removes the leverage of the defendants. We say that it just allows for the full story to be told and it accelerates all of this. They say that individuals are placed in a situation where they either have to lie or self-incriminate. We tell you that self-incriminations, while bad and like when they're false, they can like still be reversed, which means that justice doesn't necessarily like not happen when this happens because like these nerves are understood and can still be heard. On power of the jury, on power of the jury, this is where a key flaw in their contentions come forth. Because for all of these, they just say, oh, this could happen. But what we tell you is that it needs to happen, right? Like they say the juries could be biased, but that's not necessarily true. And we tell you that for it to happen, for justice to require it, they need it. They say it abuses people's past. Again, we say that the opposite could be said and it humanizes people. On unfairness, we say that again, as a whole, there's still the Fifth Amendment. We say there's still solvencies for this, and that as a whole, like the unfairness argument is largely solved by most acquittals. So for these reasons more, because my opponents don't interact with the definition of required, which is the key word here in this debate, please vote for the negation. Thank you.
Okay, good morning, everyone. My name is Dan Delgado. A quick off-time moment before we get into it, just an order of things. We're going to go over top of case, then going on to the negations case, then going over our case again, going over the rebuttals they gave in the last speech. I'm going to have 8 minutes on my clock, and unless anyone has any questions, which I'm not seeing any raised hands, so I'm going to get started. My time can start in 3, 2, 1. So, Judge, we'll open our first speech by talking about the definitions of this round. We defined it a value round, the value being justice, and the way you can weigh that is by false or unfair convictions. Now, they kind of just say justice is vague, but they agreed with it, so that's kind of just a wash. Now, the main point here is that the definition requires just means it's a single scenario. That required just means all they need to prove is in one case that the right not to testify isn't there. What we say is assume universality in a resolution. Look at the resolution, Judge. Justice requires that criminal defendants have a right to refuse to testify. It does not specify one case or all of the cases. When it does not specify assume universality in the case. Think about it, Judge. Justice requires that criminal defendants have a right not to refuse to testify. The negation has to argue that it doesn't require that. Just because it's in one case doesn't necessarily mean it doesn't require it. They're trying to wipe it off the board. As again, assume universality, it wash either way, but just and also the second thing to say is also they try saying in a single scenario where justice is met by not requiring that. What we tell you is that's impossible to determine whether justice has been met in any single court case anyway. If someone does testify against themselves and they're tried against it because of all of our contentions, we don't know for a fact if that was a fair conviction or not. So therefore, it's impossible to know if one case was fair or not. So throw that whole point out. Then they go on to say we're not just talking about the U.S. We say we need specificity around because we're talking about a legal system. And they also kind of throw around Australia, England, but they never bring up really any direct links where we should get to. So we say prefer the U.S. because we actually give you links onto the U.S. justice system, which is specified. And all of the words here are just kind of wishy-washy, which I'll get to. And then, which I'll get to right now as I get into their case. Now, the first real case is testifying accelerates justice. Now, the whole point is it tells a true story and that acquittal rates go up when they testify. Now, there's two main points to this that we like to bring up. First, the reason why acquittal rates go up when they testify is those people willingly testified. These were people who were able-bodied to testify, who were not under stress or duress or coerced to testify. This is in the status quo. They were not forced to. That's why acquittal rates go up, is because now you have able-bodied people actually being able to testify their true story without having coercion. This completely ignores any case of mental health, of any case of stress, anxiety, someone being under coercion, right? So yes, acquittal rates go up when they testify, but that's because those testimonies happened under willing conditions. The second thing is they kind of say faster justice, and they later go on to say when they're rebutting our case that even if something is wrong, if it's fast, they can appeal it later. What we tell you is speed isn't good in a justice system. We need proper convictions. A false conviction, even if it can be appealed later, still has massive mental health effects and could imprison someone wrongly, which still goes into our weighing mechanism of false and unfair convictions. We say speed isn't the priority, correcting convictions are. Now, going to the second contention, they kind of just talk about precedent, how they say, well, in other countries where people don't necessarily have the right, there's more justice, less appeals. They bring up Australia and how there's not necessarily that right ingrained in, there's less appeals. the first thing, there's various reasons why appeal rate could be less. There's completely different justice systems. Just to apply that, well, Australia doesn't do this, so therefore it must be this reason. It's completely there's there's correlation, but they never really prove causation at all. We're looking at a completely different legal system. And the second thing is well, it's being very hard to appeal if your client directly incriminates themselves. If they're under stress or anxiety and they directly incriminate yourself, an appeal is very hard when they directly incriminate themselves. You can't necessarily undermine that, especially if you remove that right. You no longer can appeal because they're not guaranteed the right not to testify. You have no case there. You can't appeal something if your client never had that right to begin with. So drop that whole point. People will still be falsely convicted, and just because they can appeal it, one, that's still harmful to them, and two, they probably won't be able to appeal because we're taking away that right for them. That third contention they have is the right that they can still not incriminate. They kind of say they complete the fifth. They kind of say this a lot through the whole speech. I like to cover it fully. That they say, well, they're not saying that you have to incriminate yourself. We say they do, because look at our definitions. We tell you that the definition of refusing to testify is to not speak on a trial. That includes pleading the fifth. The fifth is literally the right not to speak on a trial when you're testifying. We literally say in our definitions, the refuse not to testify is to not speak on a trial. That includes pleading the fifth, and that includes the right not to self-incriminate. So don't let them come up in the next speech. That was already in the round. My partner will get a golden response. So completely drop that from your flow, because in our definitions, we're saying the right not to testify is included in the Fifth Amendment. It's included in the right not to incriminate, because that's actively you refusing to talk. That's in the definition. So that whole third point has no impact, because yes, you do have to incriminate in the negations advocacy here, because we're taking away the Fifth Amendment rights. Now, going on to our contentions, we talk about bodily autonomy and the danger it is to take away someone's right to their own body. They say that we don't link out to this because bodily autonomy and unfair convictions don't matter. We say we do because taking away someone's fundamental right directly makes it an unfair trial. Judge, if you are on trial and someone's holding a gun to your head, violating your morals, that is an unfair trial. Even if nothing of the legal system is necessarily broken, if you're under duress, coercion, and your bodily autonomy is being violated, that is still unfair. So drop that whole point. Yes, we do link out to our weighing mechanism. The second thing is they bring up this acquittal rates again. We tell you that, well, the reason why the acquittal rates go up is these are willing volunteer testimonies, not someone being coerced. Again, they do not interact at all with our points about anxiety, mental health, possible stress, and juror bias, right? So yes, acquittal rates go up when the people willingly testify. Again, they bring up this whole point about they can still remain silent. No, they can't. That is the negations advocacy. It was in our definition. It went unresponded to. So no, they can't plead the fifth. And also, they kind of just throw this point of, well, we're not talking about the U.S. Well, what are we talking about, Judge? Are we talking about this random statistic from Australia? Are we talking about, they said, well, people can still be fairly tried in England? If they wanted to talk about universality, they need to bring up specific ones to fairly interact with other countries. Don't let them say we're talking about every legal system on earth and then not actually provide any ones for that. That's an unfair debate on our side. If you want to be specific, prefer the ones that have the warrants in the round and are fair and relevant to this round, which is the United States, which is our Fifth Amendment habeas corpus. We're talking about the U.S. here. They're not being specific. Now, going on to our second contention here about coercion, we talk about juror bias, about how they can use someone's background against them and force them into an unfair conviction. Again, they keep saying they can remain silent if they choose to. Judge, our definition literally says their advocacy is they have to prove that if someone has to speak on trial, that includes pleading the fifth, they have to speak in the negations advocacy. Don't let them play this fine line of they're forced to speak, but they can just go on the stand and not say anything. That's not what the negation's saying. If they're on the stand, the negation's saying they have to speak. The second story is, well, the second thing response they give to you is, well, they're going to be sharing the full story, and they have the right to share the full story. We tell you, one, in the status quo, they are able to share the full story if they would like to. And two, it doesn't actually interact with the fact that circumstantial and irrelevant background evidence exists. Someone having a previous drug issue isn't the full story of a specific crime. It's someone bringing in an unfair background information on someone to get a bias out of them. That isn't bringing in the full story, Judge. That doesn't make any sense. If you want a full story around, you use evidence and actual testimony relevant to the trial, not just some random background evidence tossed in to get a bias. Again, what we're talking about is under the negations advocacy, they are forcing people to reveal bad things about their past that can bias things against them. That is inherently unfair. And of course, the prosecution is going to take advantage of it because the prosecution's job is to get them convicted. So they will absolutely be using this against them. It is not the full story. It's an unfair story. The third thing is they say self-incrimination can be reversed. They're basically saying, well, they can just appeal it. There's two things here. One, that's completely contrary to the impact they gave you of faster convictions, because now you're going through several appeal processes to get to justice. So they're completely undermining their own impact here. The second thing we say is, okay, sure, you can appeal and fix it later. You're still incriminating someone falsely. You're still imprisoning them for some time and forcing them to go through a longer legal system. We say that's still completely unfair. To say they can just appeal it later is completely reductionary. And the last thing they say is, well, the whole story humanifies the person. It gives them a background. We tell you, no, if someone had a previous drug problem, but then got over it, forcing them to bring it up again only seeks to bring out bias out of that people and bias out of the jury. That is inherently unfair in a trial. The last thing to say is the whole third contention we gave about confusion, stutters, anxiety, increased misspeaking, all of that goes responded to in the round. And there's nothing on the phone third contention. That whole thing flows through and undermines anything they said about the rest of our case. And for that reason, I urge a strong vote for the affirmation. Or negation. Affirmation. There we go.
Okay. So for quick off-time roadmap, I'm going to go over affirmatives case, and then I'm going to go into negations case and kind of solidifying our cases in response to that. Okay, so on my first word, starting now, hello, my name is Carter, and I strongly negate the resolution that justice requires that criminal defendants have a right to refuse to testify. Let's start off with this framework issue, key issues that we have here in this round. Is this idea that it's not that we need to make this a U.S.-centered debate. One, where in the resolution does it say that it's U.S.-centered? It does not. Just saying that this is something that should be U.S.-centered does not mean that this debate is U.S.-centered. We have to take into account every justice system, and we have to take into account that justice as a whole is not only in the United States. That means that our examples of Australia, our examples of other acquittal rates going down in other countries all still stand. Moving on, they talk about this idea that we have to and also they provide no counter definition in their in their beginning speech, so they cannot just come up here and try to redefine what this means. It also means we cannot assume we have to assume the idea that this is not only about the United States. Okay, moving on to their first contention about bodily autonomy. So they're only kind of in response to what we say here is that this idea of coercion and willing conditions. They say that in response to us saying that in a situation where limiting someone's bodily autonomy can lead to more justice, they do not, in this case, they do not really interact with their weighing mechanism, and they do not have a response to this. They do not interact with the fact that their first contention does not result in false, unfair convictions. We see that in a space where people are able to humanize themselves, this leads to acquittal rates going up. We see a situation where defendants are able to testify. They have better sentencing outcomes compared to those who didn't, because they're more likely to get acquitted of these of their most serious offenses and less likely to be sentenced to these incarcerations. There's kind of no response to what we say here. And also they basically say that this doesn't take into consideration people that are under duress. But what we say here is that this allows people that have been maybe going through drug problems or maybe suffered abuse to kind of humanize themselves in the face of a jury. And this warranting is clear here. We see that in situations where people are able to humanize themselves in front of the jury, juries are more likely to believe their stories and for justice to be served. This inherently goes into this idea of false and unfair convictions that they bring up in their weighing mechanism, because we see these false and unfair convictions going down. No, thank you. I have a lot to get through.
Okay.
If I have time at the end. Moving on to our second contention, which basically talks about this idea of coercion. This is going to be a major problem here in this debate, is that they're going to say that you're allowed to be silent. They're going to say that in our world, you're not allowed to be silent, but that is just inherently untrue. Even if you buy this US idea, you have the ability to go up and to go up and bring up and not to say anything. You have the ability to go up and testify, because the definition of testifying is not that you just cannot say anything. You have the ability to plead the fifth when you go up and testify. And two, in the example of Australia, we see that this results in it working either way. We see that even if you do have to speak, take Australia, for example, we see that justice goes up. Moving on, let's also talk about this idea of this required definition. We are just saying that it's not inherently necessary to have justice. Even if it helps justice along, even if you buy this idea that it stops coercion, they have to prove to you that it is required in every single situation, that in every single scenario in which justice is carried out, that the right to that the right to testify matters in all of these that the right to testify is required in all of these situations. And one, we say that if that isn't how it works. If justice can happen in a world where you are able to where you have the right to not to where you have to justify. If justice can happen in that world, for example, in Australia, we see that therefore justice is not required, or like that having the right to testify is not required to right to not testify is not required in order to serve justice. Overall, what we're saying here is that the idea that like in many situations you can see where justice has been served with the requirement to testify, you therefore buy our idea that justice can happen in a world with or without this, but mostly in a world that, yeah, so whatever. Moving on. We bring up this idea of in their third contention, they bring up this idea of like unfairness, and they say that we just do not respond to this at all. But we say in response to unfairness and like the self-incrimination is one, humanization, and two, with this idea of ableism or mental health or all of these things that they bring up, how is it better for someone to be silent than for someone to share their stories, their mental health struggles, and all of the things that they have gone through to therefore humanize? We see this happening in Australia and all of these other situations. Okay, so moving on to our first contention about accelerating justice, they say that like we don't know if it's justice. But what we say here is there's a clear linkage between the amount of defendants finalized in the criminal court system in Australia and the amount of appeals. In Australia, we have one of the lowest appeal rates nationally, like universally. We see that there is this linkage here because Australia has mandatory testifying for defendants. They're able to humanize themselves in a way that a lot of other places are not. Multiple countries have justice systems in which the defendant doesn't have the right to testify, and we do see that justice is continuing to be served. Moving on, they also bring up how like fast justice isn't good. We say to this that court clog isn't good. We say that we do not want to see a clog in the court because that therefore stalls justice. In a world where these things are happening quicker and that people aren't appealing as often, people aren't and acquittals are happening at a faster rate, we see that court clog goes down. Therefore, this is good for justice because it moves it along. In response to our second contention about precedent, they once again make you try to believe this idea of preferring the United States. But one, where in the resolution does it say the United States? And two, they bring up this idea of like in Australia, they have a different government system. But one, they do not respond to the linkage that Australia has the lowest rate. And they do not prove to you that in all situations in Australia where the defendant has been able to testify, has been required to testify, that justice has not been served in those situations, because it has been served, and you cannot prove to us why it hasn't been served a majority of the time, or at least not one time. Okay, moving on, our third contention, which talks about like the right to not incriminate yourself is different than the right to not testify. Once again, we say that like they bring up this example of pleading the fifth, but one, you can plead the fifth when you're testifying, you have the ability to plead the fifth in our world or there. And two, when you testify, you have the you also have the ability to not say anything, or to not say everything. So you have this ability. And also they have no interaction with the key linkage that it like humanizes yourself to the jury. And the right to not and the right to tell your story leads to this humanization. They bring up this appeals case and they say like the appeals rate going on like directly counteracts like this accelerating justice point. But what we're saying here is that actually appeal rates go down in countries where you see this humanization happening here. Overall, Judge, we kind of see two clear worlds that we're setting up here. We see that in their world, we see that they're trying to make you believe that like bodily autonomy like is a danger. They try to bring up this example of like kind of coercion and all of these, and how it's kind of unfair for the defendant to have to go up and present their story. But what we say is that one, in Australia, we see that justice is able to be served when it's required. And we see that too, that in a world where you are able to humanize yourself, all of these things that they talk about, the ableism, the abuse, the mental health, are able to go down because you're able to tell your story. And that's why you see acquittal rates going up in situations where defendants are where defendants are able to testify for themselves. And in our world, we see that it accelerates justice, not only because the court clog goes down, but we also see that we have precedent in places where this has happened and has been successful. And moving on, we also show you that the right to incriminate yourself is right not to incriminate yourself is different than the right to not have to testify. Saying that, so this idea that you cannot go up there and be silent is not true. You have the ability to plead the fifth when you're testifying in a court case. Overall here, that is why you should vote for the negation side of this today.
Cool. Okay, is everyone ready? And then I'll give a quick off-time roadmap and jump in. Okay, as a reminder, my name's Theodore Sipkins. I'll be your third speaker. And for a roadmap, I'm going to go over the key framework issues here. There's a few of them. Then I'll go over their case. Then I'll go over our case. Then I'll weigh this debate, even though there's going to be some implicit weighing throughout, but I'll crystallize it at the end. Cool. Everyone ready? Awesome. Okay, sounds good. Begin in 3, 2, 1. On framework, let's start off with the definition of required, because this is the single most important thing in this debate. This debate ends when they don't do an adequate job in explaining what required means. They don't do it in their first speech, and then they try and say assume universality in their second speech. But like Carter tells you, the definition of required is very, very, very clear. Required means that for justice to exist, it would have, under this resolution, the affirmation has to prove that for justice to exist in any form, it needs to have we need the right not to testify. We tell you that if justice can exist in any instance without this right, it is not required to exist. It is not required for justice. We tell you that they don't do an adequate job of explaining why you don't buy this definition, and we win here alone. On the Fifth Amendment, we say that they try and twist like what testifying means. We say that like we give you the warranty in my first speech that you can testify and still not incriminate yourself. You can testify and still hold on to your other rights. That's not something that's adequately refuted. They only just say, oh, well, our definition says like you have to speak, but like we say that you can still choose when to speak, even if you're on the stand. On the US thing, they say like assume specifics that we don't warrant out to like Australia and the UK. We tell you we very much do. We tell you we very much prove to you why like their justice systems need to be considered, because they provide the adequate examples here to counterbalance the US. We also tell you that they don't explain why we're preferring the US here to any other thing, and they just don't really warrant here. Don't let them get up here in their third speech and like and bring that up. On the affirmative case, as an overview, none of their impacts really matter because one, they don't link out to the weighing mechanism one they provide, or two that we provided, which was a fact resolution that just never went responded to this entire debate. And two, we say that all of their impacts are reversible by appeals and by like this process and by the negation itself. And so because of this, you shouldn't weigh their impacts, because even if justice is delayed, it gets served eventually. And because of this, reversibility solves for everything. Let's go through their contentions. Their first contention is bodily autonomy. We say that this doesn't violate their bodily autonomy, one, because of the right to not incriminate yourself, but two, because of the right to simply just tell your story. Also, their impacts don't link out here, because even if they say it leads to like unfair convictions, we say that these can be reversed. Two, on coercion, we say that like as a whole, again, Fifth Amendment solves for this, and like furthermore, again, like humanizing yourself to the jury is the most important thing here, which is why acquittal rates go up when people testify. They just say, oh, this is because they're willingly testifying, but we say that it's the same thing either way here, because like acquittal rates are going up generally. If you have everyone testify, acquittal rates will go up, which means that justice goes up. On unfairness, they say we never respond to this. We very clearly do. Again, like use the Fifth Amendment response and use the fact that like, again, that even if people are in an unfair situation, it is reversible. This overview applies to all of their impacts. They don't link out here to the crucial impacts in this round. On the negation, as an overview, our warranting largely gets untouched when they just try and cross-apply their definitions. On acceleration, we tell you that they just say, oh, well, it like just as fast is just as bad. But we say that court clog is really, really bad. And we say that from my first speech, more justice happening faster means that more justice happens. And they don't respond to this. Don't let them bring it up in their third speech. On precedent, we tell you that this is the most important argument in the round, because what it proves to you is that as a whole, like what it proves to you is that justice can happen without having this right. We tell you that because there are less appeals, what it means is that most people are satisfied. They say, oh, it's just a different system, but they don't explain how it's a different system. They don't explain why appeals wouldn't mean that more people are satisfied. What we tell you here is we have really clear warranting. They don't respond to it. And then finally, our third contention is that the Fifth Amendment, like this right still applies. They don't respond to this. I've already gone over that. Now, quickly weighing, let's go over their mechanism of like increasing like fair convictions. We tell you that what causes less convictions is our side, because we've increased the rates of acquittal. But we also tell you that reversibility is weighable, and you shouldn't weigh something if it's reversible, because this means that justice is still served and justice can happen without this right. On our mechanism of what is more true and what's required by justice, we tell you that the simple fact that in at least one case justice has actually happened, even without this right, and thousands have happened, that we're winning here, because it proves that justice can exist without this right. Thank you.
Okay, hello everybody. Again, my name is Cosette Calderon, representing the affirmation from Benicia. I'm going to have 5 minutes on my clock. I'm going to give a quick off-time roadmap. I'm basically going to be going over all these points of clash that my opponent brings up in their last speech. Then I will be going on to what we believe Or well, I'm going to start with what we believe is the most important issue in this round, then go on to what my opponents bring up in their speeches and give some golden responses, and then I will go on to why. Is everybody ready? Great. Oh, I'm already unmuted. Okay. My 5-minute timer will begin in 3, 2, 1. Hello, judges. We still strongly affirm the resolution that justice requires that criminal defendants have a right to refuse to testify. So what do we believe the most important issue in this round that you are voting on? We believe the most important issue in this round is the fact that mental health issues are so prevalent and they are ignoring it. The negation ignores this issue. Why? One, because by forcing people with mental health issues to testify, you are directly dehumanizing them by forcing them to self-incriminate themselves based off of confusion, based off of anxiety, based off of judge bias. But the second thing that we say is we're also saying that bodily autonomy is ignored. The second most important issue that we believe in this round is the top of case. My opponents come up here and they give you a few big things. They say, one, they only have to prove that in one case, justice is served by forcing somebody to testify. They say that we never tell you like why this isn't true. We absolutely did. My partner came up here. He literally said, assume your universality, because the resolution doesn't state it's just for one person, it's for all, right? It doesn't specify. You should assume all. Why? Because it's more fair to the round. My partner said this in his speech. The second thing that we say into the top of case about the weighing mechanism, they say we never test. Sorry, I apologize. Going on to talk about whether it's specific to the US or whether it's specific globally, they say the negation says that we have to consider it globally. They say that we never testify against this. We never try to say this is wrong. We did try to say this is wrong. Why? We say they never give you warrants as to why we should include everybody. The US is the most specific thing. The affirmation is the only one to warrant out why we should believe it is the US, but we're going to win under either way. It doesn't really matter. Okay, going on to a few things. They talk a lot about how you can be silent, and it doesn't matter if you're testifying in either world, you can still be silent. The issue is they miss our response about how the Fifth Amendment includes both self-incrimination and the right to refuse testifying. What does that mean, Judge? It means that if you are going to self-incriminate yourself, you can't just remain silent. The Fifth Amendment and removing the Fifth Amendment directly affects your ability to stay silent. Don't buy this. It doesn't make sense. In the amendment, it literally
Are we back? Sorry, we just noticed our meeting cut out. All right.
Is it okay if I just continue from where I was? I have 2 minutes on my clock still. Is everybody okay with that? Okay.
Was there any point that her voice cut out where her speech wasn't being heard? Or did it just cut? Just start like 20 seconds back on your flow, just to make sure.
Okay.
You cut out, at least for me, when you were describing the content of the Fifth Amendment.
Okay, there you go.
Okay, great. So I'll just start from there. I have 2 minutes and 18 seconds on my clock still. My time will resume in 3, 2, 1. The Fifth Amendment includes both self-incriminations and the right to not testify. What does this mean? It doesn't mean that the negation can just take one of those things away. If you're forced to testify, you're going to be forced to speak. You can't just stay on this line and be silent. They're taking away the Fifth Amendment, essentially. Don't buy that. Okay, the second thing they say is that none of our impacts actually link out. We say they ignore this. We tell you that bodily autonomy, by not including bodily autonomy in this round, you're literally forcing people to give up their right. That's not justice. That's not justice. Okay, moving on.
Let's do 1 minute.
Moving on, we're going...
Okay.
Moving on, we're going to do a quick two-world analysis. So let's look at the negations versus the affirmations world. In the negations world, you are forced to testify. They say this is going to bring more acquittals, but they ignore our two responses. And while they make a good case that acquittals might go up, the issue with that is, one, that happens in other countries because it is willingly given, testified, right? People are willing giving their backstories. Two, what happens when it's not willingly given? Anxiety kicks in, stammers kicks in, pressure happens. People start to self-incriminate themselves, and background stuff comes up, and judges feel biased, right? It's going to lead to more false convictions. Finally, let's weigh what happens. Well, the negation says based on truth, they win with one case. Then cross-apply that to us as well. With one case, we've proven to you that under mental health issues, if one person has mental health issues and they stammer, it's going to cause mass chaos, right? That person is not going to get justice. So clearly we went off of their weighing mechanism. But based off of our value of justice and upholding the justice system with false or unfair convictions being reduced, we don't need speed. We need right convictions. The appealing process that the negation tries to convince you will work is also going to clog the system just as badly. You shouldn't let them win off of that. It doesn't make sense. In both worlds, it's a wash. But the second reason, why are we winning? The magnitude of forcing people to be falsely incriminated is high. It's far worse. So I strongly encourage a vote for the affirmation. Thank you.
Good debate, you guys.
Good debate, guys. That was fun.